The Supreme Court now considering whether the president's tax and financial records will have to be turned over to either 3 House committees or Manhattan's DA following hours of arguments this morning. At issue, whether 3 House committees or the Manhattan District Attorney can force a third party to turn over the president's personal tax and financial documents for several years before he was elected. But a number of questions arose about whether congressional subpoenas absent a legitimate legislative purpose might be used to harass a sitting president, and how that subpoena power could be appropriately limited. Justice Alito noted the House's attorney seemed to offer no limits at all.
In your view, there is really no protection against the use of congressional subpoenas for the purpose of preventing the harassment of a president, because the only requirement is that the subpoena be relevant to a conceivable legislative purpose, and you can't think of a single example of a subpoena that wouldn't meet that test.
It was in the second case of the day involving the Manhattan District Attorney's attempts to get the records in connection with a grand jury investigation where the president appeared to face the toughest headwinds. All sides seem to agree the president cannot be treated like an ordinary citizen, yet Justice Kagan adding this.
But it's also true, and indeed a fundamental precept of our constitutional order, that a president isn't above the law.
And whatever the justices decide, that decision is likely to land in late June, right in the middle of the presidential election. So let's bring in Constitutional Accountability Center President Elizabeth Wydra and Judicial Crisis Network President Carrie Severino. Good to have both of you back with us.
Great to be here.
It's great to be here. All right, I want to play a little bit more from Justice Sotomayor in that first argument where she said, looking back into these years before he was the President Trump, he was talking about running for president, and so it's relevant to see what was going on in the years leading up to his actual run. Here's what she said.
Why is it that Congress can't believe that looking at longstanding relationships and how those relationships changed or didn't change is important to knowing what undue influence might be occurring?
So, Carrie, why shouldn't House committees who are investigating those kinds of things, undue influence, potential foreign influence, be able to look at those records?
Well, I think actually it puts her finger a little bit on some of the challenge here, which is precisely the reason the House wants to look into is because they're interested in making things difficult for the president himself. That's one of the things that the court was really struggling with. Is there any limitation? Any Congress could say the same things about any future president. And it wasn't just the conservatives who were concerned about this, the idea that there's now limitless ability, if you say this is okay, for Congress to request records from any future president. Even Justice Breyer said this really could enable a future Senator McCarthy to be requesting documents of a future FDR, for example. We don't want that to be yet another political tool and excuse to distract the president. It has real serious separation of powers concerns. And so I think the courts, again, he's obviously not above the law. No one is. But there has to be a way to separate out the political harassment from actual needs for legitimate case or legislative effort, independent of just the politics of the president himself.
Yeah, so the first case argued today was about those 3 House committees who were trying to get the records not released from the president, but from a third party who would maintain financial or tax records for the president. But the second case involved the Manhattan District Attorney who's trying to get these in connection with a grand jury investigation. And Elizabeth, it sounded like the president's going to have a much harder time in that second case today. There were all kinds of things that were brought up, but there was this question of whether prosecutors across the country could bring these kinds of investigations to fruition so that they could, quote, harass a president by asking for these kinds of documents. How do you respond?
Yeah, so I think actually the president is going to have a hard time in both cases. And that's because, you know, if you take away the political heat of the fact that this deals with President Trump, which he seems to be just a hyper-political figure. It deals with his tax returns, which is obviously a hot-button issue. Really what this is about is investigative bodies, whether it be the Congress or the state local grand jury, doing their jobs to hold people accountable, to be the checks and balances in the case of Congress that the Constitution sets that body out to be. And certainly there are instances in the past, we've had presidents from George Washington to the present comply with congressional investigations. We've had grand jury investigations into sitting presidents. People might remember the Paula Jones sexual harassment case against President Bill Clinton, where these presidents have complied with legitimate subpoenas. So while these cases are nominally about President Trump's tax returns, they're really about the ability of Congress on the one hand and a grand jury on the other to do its job of oversight and holding everyone accountable to the law, whether you're president or an everyday citizen like you and me.
Yeah, okay, so we'll wait on that. But quickly before you guys go, I want to get you to weigh in on the fact that Judge Sullivan has decided to hold open the Flynn case after the DOJ recommended dismissing it. He said, okay, we're going to consider that, but I'm going to allow some people to file briefs if they'd like to weigh in on this. Sidney Powell, who is General Flynn's attorney, said in her filing tonight, the proposed amicus brief has no place in this court. No further delay should be tolerated or any further expense caused to him and his defense. I'd love to get a quick comment from you both about how unusual you think this is or is not. Carrie, we'll start with you.
Yeah, this has been a really egregious instance of abuse of power already. I think Flynn has been through a great deal, so I think I definitely understand the concerns that further delay in this case compounds the outrageous political effort of the attempts to kind of entrap him in this case. So I think that's going to really weigh heavily.
And Elizabeth, I want to get you in quickly before we get cut off.
You know, Judge Sullivan is a very well-respected jurist, and I think he just wants to make sure that the actions that the Department of Justice has taken are for justice and are acting on the best interests of the nation, which is really the Attorney General is the people's lawyer. He's not President Trump's personal lawyer. So, you know, the idea is that are these actions going to serve justice rather than just a political agenda?
We'll stand by. That one's not over. Thank you both for being with us. More news next.